Today's topic is Transfer of Property Act, Section 47, Section 46 and 54 and 123. These are the sections covered relating to transfer of property. Please answer me whether the transfer of property after registration, it is a contract or not. That I want to get answer from you, whether it is a contract or not. What do you say, sir?
It is a contract, sir.
Yes, sir. Now, this Transfer Property Act, it is based on possession follows title, not a title follows possession. This word always using before the court. Sir, whether the registered sale deed got it by him under contract, whether he is having a title to the property or having possession of the property or not. So that is the question going to be decided under section 54. Now, the 46 says, transfer for consideration by persons having distinct interest. 46, what it says, whatever the property going to be transferred, he has to get the consideration amount from the transferor. Such being the case, when the persons who are having the ownership of the property, ownership, I think you know under the jurisprudence who is a owner. Owner means having title to the property, having possession to the property, having right to alienate the property, and handing over the possession. It is all the four ingredients is required to be transferred the property by way of registered sale deed. So if he is not at all owner, how can he sell the property? So that is the question to be decided under section 47 for consideration. And another section 47 is concerned transfer by co-owners of sale in common property. Why it has been introduced? I think you must know wherever the co-owners are available pertaining to the property, means either in the joint family property or in the ancestral property, or some friends they want to purchase the property by virtue of co-ownership. So co-ownership means there is a right behind it. What is the right? Called as preemptive right. Preemptive right means until and unless co-owner accepts to alienate the property, he shall not alienate the property. Therefore, he is entitled to file a suit for partition. Kindly maybe look into, even though they are not related to each other, but still under section 47, if the co-owner having a right to the property, he shall be getting acceptance of the co-owner and sell the property. That is called as preemptive right of the property. Now, next is very, very important. You have come across so many sale deeds, section 48 of Transfer of Property Act. That is, now, today I want to alienate my property, but I have already alienated the property to somebody else, whether prevail over the earlier sale deed or present sale deed. That is the question to be decided under section 48 of TP Act. So means always you transfer means this is a contract. Transfer while he has made particular property, he cannot having a right to alienate subsequently. So therefore, section 48 always restricted. You cannot transfer the property by virtue of already you have alienated. You cannot transfer the property by virtue of section 48 because whatever the prior sale deed is available. So if the prior sale deed is available, automatically he cannot entitled to sell the property. These are the sections to say protective interest over the property. Protective interest, because when the owner having right, how to alienate the property. All these things, these sections 47, 46, 47, 48, and these sections are protective in nature. Co-ownership and prior sale deed and other preemptive right and other one is transfer. So now the section 54 I want to come to. 54 says, please note down the section 54, how it is restricted. Restricted and sale has been defined. This is the definition available in the section 54, sale. What is meant by sale? Just I want to read. Sale is a transfer of ownership in exchange for price paid or promised or part paid or part promised. So I think you understood. Now, example, entire consideration amount has been paid, automatically it is transferred. There are terms and conditions. Promise he wants to make some part of payment, whether it is a transfer or not. So when it should be questioned and remain, he has not at all received any amount, but still he has executed property in favor of the purchaser without taking any consideration amount, any sale, any consideration amount, he has not received because the promise between the parties, section 54, why it is important, because in your practice, you have to come across to say that what is meant by sale. Sale means entire consideration amount, promise to pay part consideration amount, promise to pay the some more amount in future, and promise to pay until and unless payment is made, not going to take possession of the property. So ownership going to be transferred only after completion of the transaction. Section 54, be aware that because several judgments are passed, several uh, the sale deeds are set aside because of this reason. And the limitation going to be play role. While questioning this sale deed, the aggrieved party means who has executed the sale deed. When the promise is not satisfied, he shall question immediately within 3 years from the date of not promising fulfilled. So kindly maybe look into when he has not sold the property, promise is broken because he has not paid the money. So therefore, we have to question the said sale deed within 3 years limitation, within 3 years period from the date of execution of the sale deed. Calling him, opportunity should be given, and all these things, promise is made. So therefore, he has not executed the sale deed and he is not a owner. And to declaration, suit shall be brought under section 34 of specific relief act, 34 or 38. So you have to go to specific relief act and you claim the relief of cancellation of the sale deed because the promise is broken. So this is called as section 54. Please note down, because it is very, very important during the course of your practice. Whether the sale deed earlier executed, you have to find out only by way of encumbrance certificate in form number 15. Form number 16 always giving, but form number 15 is fully described when the sale transaction was took place, and from beginning you have to get the from sale deed when it was executed. From beginning you have to ascertain from the encumbrance certificate in form number 15 only. If it is sale has been made, you should not assure to your client, yes, we want to take in a recourse of the action, but limitation is always 3 years. Within 3 years, you should take this matter before court of law. So section 54 is also stated, for the purpose of this subsection, no transfer made without consideration shall be deemed to have been made with intent to defraud by reason only that subsequent transfer for consideration was made. Now, whatever the transaction earlier, he wants to misrepresent or fraudulent document he has executed, that shall be questioned within 3 years. This is called as section 54. So my humble request, just you note down, these are the decisions for section 54 is concerned, recent judgment 2022 AI All India Appellate Reporter bracket civil page number 1, Honorable Supreme Court Lordship dealt directing the parties to hand over possession, though the civil court on the ground of the limitation is not properly concerned, on the ground of whether the earlier sale deed brought into notice to the court. So all these facts are taken, but in the evidence it was failure before the trial court, before the high court, subsequently Honorable Supreme Court directed to hand over. This is the case of Kenaval Krishna versus Rajesh Krishna. So please note down 2022 All India Appellate Reporter civil into bracket page number 1 of Honorable Supreme Court. So you have to get down either in AIR or ILR or in KCCR, anywhere else you find out if it is not available with you, because I am a subscriber, I am getting these every month, the books from the concerned authorities. So therefore I have read this judgment, and it is promised to pay or withheld of payment is void in nature. Whatever promise made after getting the registration, he is not fulfilled, automatically it is void in nature and it is not maintainable in law. Another one decision, AIR 2001, Karnataka 442. It can be also read because within 3 years, that is the limitation point of view, it has been decided in that judgment, AIR 2001, Karnataka 442. In that judgment, whether the transfer of property is a contract or not, all these points are involved in that judgment. So you please note down all these things. Now, another two judgment, whether the sale deed, prior sale deed, whether they authenticated document or not, another two judgment under section 48 and 47, ILR 2003, Karnataka, page number 3042, and AIR 2019, Karnataka 181. So these are the judgment decided on the facts of section 47 and 41. And another section, because you are being a practicing lawyer and you are tomorrow going to advise to your client, stating that whether the sum of the person going to release between the, kindly maybe look into what happened. The entire family entered into an agreement of sale or entered into an executing the sale deed in favor of, but promise has been made going to pay the amount to some family members later stage. So that promise was broken. So what is the next for this? What is the next for this? So therefore, some of them family members, what happened? They are in need of money. They have executed the release deed, unregistered release deed. Kindly maybe look into, this is the judgment of this Honorable Court and Supreme Court. Several judgments are there. The release deed, Hakku Bidugade Patra in Kannada, because some of the family members going to execute the release deed, Hakku Bidugade Patra. So that is called as relinquishment deed or release deed going to execute some parties. If it is not registered, it is no value in the eye of law. So that point has been decided in case 2015-2 KCCR 1368. So therefore, you should make out the release deed is also shall be registered, because today we are in the stage of learning or in the stage of addressing argument or in the stage of convincing the party. If the release deed made, some yesterday document came to us. The 5 daughters from Kanakpura, they have received 1 lakh rupees each and relinquished their right in favor of their brother. 5 sisters executed unregistered document in favor of their brother and executed the unregistered lease deed. It can be used for the purpose of cross-examination. For the purpose of cross-examination. But based on that, it cannot be used because it is not registered document. It is not a relinquished deed. It is not a registered document. And also, it is not leaving their right in favor of them. So therefore, you should make out the release deed shall be registered. It is a mandatory provision. It shall be registered. And this is the judgment passed our own Honorable High Court of Karnataka, detailed judgment, and referred so many judgments from the Honorable Supreme Court. Once release deed cannot be executed without registration of the document. So these are the section 47, 46, 47, 48, and 54 is concerned. So my humble request, why these sections are I am giving for you, daily our practice purpose. Daily we are come across the problem from the people at large, and this type of document cannot be taken into consideration. So I have come across so many documents, such documents, but for the purpose of collateral, who can take assistance of these documents, whether you have lost your right by executing unregistered deed, and during the course of cross-examination, we have to confront the document. Yes, if it is over, if she has admitted, yes, we have released it, but it is not registered because we don't want to go to the register office. Amicably, we have settled. Therefore, we have got it executed among the. So this fact came before the Supreme Court. What happened? Whether the unregistered document between the family members can be registered or not, Kale versus the sub-registrar office. So in Kale versus that came to be decided, yes, Pan Parikat means the whatever agreement took place among the family members, it cannot be registered. But if long time they have used, acquired the right and enjoying the right, and some of them sold the property, whatever the allotment has been made through this deed, so automatically it is confronted. It is confirmed that this document, intention of the parties to be bring in that case, in the year 1995, it was decided that the citation I want to give to you. However, the unregistered document is also can be used for the collateral purpose during the course of cross-examination between the parties. But that document is not authenticated document, but however, based on the facts and circumstances, we have to prove whether this document is rightly executed or not. That's all. For the collateral purpose, we have to take chance to prove that already the relinquish has been made. So therefore, they are not having right to claim further of the partition or property. It is ancestral property. Because what happened, why this fact I am telling to you. Now, section 6, last time I have given to you, section 6 introduced on on 2012-2004. That is the enactment came into effect, and same has been effected 1/1/2005. The women are entitled equal share by virtue of Hindu Women's Right of Property, that is Hindu Succession Act of Women's Right of Property, that has been amended under Section 6. Therefore, even though they are relinquished long back, but still they are coming before the court. Yes, I am one of the co-partner. I do not know. My brother was mismanaged and he has taken the signature on the blank paper and got it written by himself without our consent. That all the type the defenses, because the fraud wants to play it before the court. And another one thing I want to say, because the fraudulent act on the court, it is seriously taken. It is one page judgment. Supreme Court was dealt. Supreme Court was dealt Changavala Raya Naidu case. In that case, what happened? The court, they have come before the court, suppressing the fact, already executed the document, but still they want to claim. And at the stage of appellate, come across that particular document has been placed by the respondent. So fraud played on the court, serious action has been taken and rejected the appeal with cost. So therefore, imposing penalty is also high nowadays. They cannot suppress, they cannot come before the court with clean hand, and they should come before the court with clean hand and balance of convenience in their favor. They should file their case before the court. So therefore, that is remarkable judgment. Changavala Raya Naidu case. Anybody you ask, I want to give that citation to you, and you go through that also. So this is the fraud played on the court, either of the parties, either plaintiff or defendant, either appellant or the respondent. Anybody has fraud played, so they shall be. That is the 1995 Supreme AIR 1995 Supreme Court 853. That is the citation, because always I am placing before the court. This is the fraud has been played before the court, how they have fraud has been played. So this judgment is also helpful for us every day for our practice is concerned. And you note down 1995, yeah, 1995 SC 853. That judgment is very helpful for you to prove that whether the suppression of fact, not approaching clean hand, and earlier document got it executed, still he has not placed before the court. Therefore, the fraudulent act has been played by him. So therefore, that judgment is helpful to the public at large. And you see that that judgment is also for helpful for you, and you get the judgment 1995 853. And these are the sections I have stated. Now, most important topic is this, because always come across this is the problem before the court. Before the court is concerned, because always what is meant by gift? Section 122. Please kindly maybe note down Section 122 gift. Gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration. The word kindly maybe look into. Without consideration by one person called the donor. So gift, under the gift deed, if some consideration has been passed on, it is not a gift at all. And to another called the donee and accepted by or on behalf of the donee. The acceptance must be there between the parties. So I think you understood the transfer of movable and immovable by way of gift without consideration. Now, next question, section 123 is very, very important for you. Stays. This is section restricted the donor who is going to gift away the properties movable or immovable. A restriction. What type of restriction made under section 123? That is transfer how to effected 123, because you are come across so many problems during your course of your length of practice. So therefore I am providing you, this is the nature of gift. For the purpose of making gift of immovable property, the transfer must be effected by registered document. Registered document registered document signed by or on behalf of another donor and attested by at least 2 witnesses. Kindly maybe look into, it must be registered before the sub-registrar. Any gift, movable or immovable properties made by any person, it shall be registered, mandatory provision. So therefore, this is also one thing. And another thing, for the purpose of making gift of movable property, the transfer may be effected either by registered instrument signed as aforesaid or delivery. Such delivery may be made in same was as goods sold by the delivered. So my humble request here, why I am giving this particular section, because I have come across one case that is called as before the civil court, now in RFA, OS 7060/2012. I have come across in this case 2012 onwards. I have dealt this matter between Chikkaramai Reddy versus Annai Reddy. That is the case you have to consider. 7060/2012. Whether the gift deed registered document or not. This is the case between the sisters. Chikramai Reddy's wife and Annai Reddy's mother, both are the sisters. And the sister came, Chikramai Reddy's sister came to Bangalore from Chittoor. And she has houseless and having children of 7 children and could not able to stay at Bangalore. Therefore, she has requested to her sister, elder sister, provide me accommodation. So the accommodation has been given. Then she has started to refuse to hand over the possession because it is word has been used. Kindly maybe look into. Though the provided accommodation under gratuitous accommodation means just a sister being a gratuitous relief, gratuitous relationship between the sisters. Therefore, she has given accommodation to her. Then what she did, she died. Then all the husband and children filed a suit against us, stating that unregistered gift deed has been signed by all of you. Therefore, gift is valid. But point of law is very clear, mandatory provision. It shall be registered document. It shall be registered. So therefore, whatever unregistered document cannot be taken into consideration since from 1954, that is the TP Act when it was introduced. Such being the case, she don't have any right to claim, or her husband or children, they have filed a suit for declaration against us. Declare that we are having possession by virtue of unregistered gift deed. So then matter has been decided by the trial court and dismissed the suit. Dismissed the suit filed by the sister, her husband and children dismissed the suit. Now, this fact has been brought before the Honorable High Court RFA 915/2019 and it is still pending. So my handover to you to state that whether the gift deed which shall be registered or not, it shall be registered and that document shall be placed before the court, and if it is not registered, they are not eligible to get any relief from the court. So therefore, in that case,
Sir, you are on mute, sir. Suddenly it went on mute.
I have kept my this one. Right. And unregistered gift deed of AIR 1993 Delhi 19 RN Davar versus Gangaram Sharam Dama. Gangaram Sarvadhama. AIR 1993 Delhi 19. Unregistered gift deed of immovable property cannot be taken into consideration. So it is one thing you have to note down, because it is not possible to say the unregistered gift deed cannot be taken into consideration. And another one, AIR 2012 SC 1727, that is also section 54. It was decided by the Honorable Supreme Court. Specific relief act, suit for possession by person other than the title holder, nature of pleading and details to be given therein. So specific relief act for the mandatory injunction, all these things they decided in this case because it was not registered document. And note down, this is the law has been laid down by the Honorable Supreme Court. They cannot having right to claim even temporary injunction. They cannot claim, even they are not claim any equity relief also, only by way of they have to leave the premises. So therefore unregistered gift deed cannot be taken into consideration. I won the case, and because I have read over. And gift existing and future properties, gift several of whom one does not accept, and when gift may be suspended or revoked, all these section is available for you 123 onwards, and this is the chapter 7 of the TP Act under section 122 to 127 deals with gift. So therefore my humble request, because tomorrow you have to say. And another one thing, because why I am bringing this, ಅರಿಶಿಣ ಕುಂಕುಮಕ್ಕೆ ಕೊಡ್ತಾರಲ್ಲ ಸ್ವಾಮಿ, ಅವೇನ್ ಗಿಫ್ಟ್ ಅಲ್ವಾ ಅದು ಅಂತ. ದಟ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಅರಿಶಿಣ ಕುಂಕುಮ ಕೊಟ್ಟಂತಹದ್ದು. ಇಟ್ ಈಸ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ and given by the parties. If the denies, she has to prove it was given at the time of my marriage. All these things available in the 123. So it shall be registered. If the mandatory provision is there, if it is not registered, it thrown into dustbin only. That document is no value in the eye of law. So these are the point today I have dealt. Sorry for delay. However, please ask any question if you are having.
One question, sir, relating to either transfer of property or gift deed. The question is, if the property is already mortgaged to a bank, there is a bank loan running on the property, and the person want to gift deed it to somebody else's name, is this possible?
Sir, one thing, there is a already liability on the said property. If she wants to accept the liability, should mention I have mortgaged the property and you get this property by way of gift and clear the loan or clear the mortgage, and then only you are the owner. That is the registered document you can make out.
But gift, as you said, section 123 is gift without consideration, right?
Yes.
So here without consideration means no.
So because that recital, he is already having liability on that property. He cannot gift away because he don't have right to gift. But conditional gift deed means he can Because transfer of property, section 47 you go, 48 you go, but here is a case while gift away the property and he can put the condition. That is the liability on the property and your acceptance going to be only after clearing the mortgage.
Mhm. Okay, sir. Thank you.
Right, sir. I think good lesson today for you. You must practice always, you convince the parties and these are the decisions available for you and you go through those decisions. It is better for you in future also. Yes, sir. Anybody question? Any questions?
Sir, one related question. Suppose, as you said, since there is a liability with the bank, that gift is not possible, but a conditional gift is possible. But can this be, can the owner of the property make a will?
Sir, will is always available, sir. Will is operating only after his death. He can write down the will, sir. No problem for that. Section 68, I want to detail Indian Succession Act and Limitation Act. I will bring to you next week. Sir. That is
Yeah,
important
thank you, sir.
for you.
No issue.
Concern. Any ladies? Any question, women? Because it is your right to claim at the time of providing the gift, at the time of marriage, offering, and those called as gifted because it is women's property dealt in under section 14 of Hindu Succession Act, Women's Right of Hindu Succession Act. So therefore, under this Transfer Property Act, it is not a gift. Gift shall be registered one. Shall I close now?
Yes, sir. Looks like nobody has a question. People are quite comfortable with their property.
Thank you. Because immovable property comprising specific relief act and TP act, you must both acts should be keep with you and give advice to the parties. That is better for you.
Today's topic was very nice, sir. We'll go through 47, 46, 54, and
Yes,
123.
small section. Only 3 words, 4 words are available. You go through these sections. Always it is helpful for your practice. And limitation is also applicable to this. 3 years. It is fixed. Any document questioned before the court, there must be 3 years of limitation. Within 3 years, they have to question that document.
As per the Hindu, as you said, Hindu Property Succession Act or something you just said.
Yes.
As per that, father's property, parental property, daughter is equally, daughter has equal ownership, right, sir?
Co-partner, that is a last date of hearing. I have told you AIR 2020 SC 3717 that Vinit Sharma versus Rakesh Sharma case, sir. Co-partners, para number 66.
Yeah.
She is a co-partner of the family.
Mhm.
Hmm. One,
Yeah, my question is a little different, sir.
yes,
See, as you said before, I remember that daughter has equal, rights to the parental property, right?
yeah.
So now, after the death of the parents,
Hmm.
why should the daughter be, going for a relinquished deed? You just said, right?
Really?
Or release deed.
Yes, yes.
So why is that required? Because as you said, as per
Because
the
you see, she is a co-partner. She can claim equal right. Therefore, better to get a relinquished deed or release deed from her, because she should not claim again and again. Now, in one case, I am dealing before the Honorable High Court of Karnataka. 1956, the uncles executed the release deed. The four uncles, they have executed relinquished deed 1956. Now the suit has been brought in the year 2012, saying that we have reunion together and there is an unregistered agreement. Therefore, we are entitled to claim partition. That has been rejected because once the right of their their ancestors executed the release deed in their favor, the matter is end. They cannot claim because stepping into the shoes of the their father was relinquished. Subsequently, he said that no, we are joining together and cultivating the land. Therefore, we are entitled. No, it is not possible. So it was decided long back, and I am fighting before the High Court now.
thank you, sir.
Welcome, sir.
Sir, one question from my end. So, if wife and husband has actually purchased some property and they become a co-owners, so how their rights will be distributed and how it was decided?
Sir, yesterday I have filed a case before the family court. Now, the both of them are the co-owner, and she stated that I am having two children. You must execute release deed in my favor because I have to maintain them in future by getting the rental income or anything. Apartment has been purchased. This is the problem. The software students, those who are married and they are going abroad, and immediately they are coming to us to getting the relinquished deed or release deed in their favor, because all these problems come over. Now the both of them, they have approached me. Then she wants to property required because the two children are there. Therefore, let him execute. Being a co-owner, he shall execute towards maintenance of the children. Ladies are not questioning anything because transfer of PP Act, it is very, very interesting subject.
Hello, sir.
Yes.
One question answer.
Yes.
There is one grandmother. She died, and there is one property in her name, and it is not. There is no will or gifted. Nothing is there.
Yes. Testamentary documents are not available.
Yeah, there are 5 children to her, and there are like 20 grandchildren to her.
Yes.
So will the right go to all of them? What is how?
No,
it is
sir.
done?
No, sir. The heads are available. Each head. Now the 5 persons, children to them. the 1 to 5 automatically goes to them, upon which the children are entitled from the 1 to 5, not for any more than.
Okay, sir. And in that 5 children, one
Hmm.
person is dead.
Well, his wife and children, that is one share, they are entitled.
Okay, sir. Got it. Thank you.
Thank you.
இது ஆந்திரா, இது கர்நாடகா இருக்கு. என் காலேஜ்ல வந்து புதுசா காலேஜ் டெவலப் பண்ண சொன்னாங்க, ட்ரஸ்ட் பண்ணது.
சொல்லுங்க, என்ன சொல்லுங்க, கேளுங்க, என்ன சொல்லணும் சொல்லுங்க. சொல்றேன், தமிழ் வேணும்னு சொல்றேன். நானும் விருதுநகர் தான் படிச்சேன்.
ஓகே சார், ஓகே சார். இப்பதான் சார் வந்தேன் டிரைவிங்ல இருந்தேன். வந்து சொல்லியிருந்தாரு, இந்த மாதிரி காலேஜ் என்ஹான்ஸ் பண்றோம், இது மாதிரி ப்ரோக்ராம் பண்றோம் அப்படின்னு சொல்லியிருந்தாரு. வந்த உடனே ஜாயின் பண்ணேன், வந்த உடனே ஜாயின் பண்ணேன். ப்ராப்பர்ட்டி ஆக்ட் சொல்லி செக்ஷன்ஸ் போட்டிருந்தீங்க 54, 47. அதான் எடுத்த உடனே வந்து வைஃப் என்னன்னு கேட்டுட்டு இருந்தாங்க, சொல்லியிருந்தேன். நீங்க லெசன் பண்ணிட்டு பேச ஆரம்பிச்சிட்டீங்க.
ரைட், ரொம்ப
சந்தோஷமா இருக்கு சார் இந்த மாதிரி கிளாஸ் பண்றது. ரொம்ப ஹாப்பியா இருக்கு இந்த மாதிரி கிளாஸஸ் கண்டக்ட் பண்றது.
ஆமா, எனக்கு இன்ட்ரெஸ்ட் இருக்கும். கம்ப்ளீட் எல்லாரும் படிக்கணும், எல்லாரும் கிளீனா அட்வைஸ் பண்ணணும். இந்த பப்ளிக்கு டீவியேஷன் செய்யக்கூடாது. அதுதான் என்னுடைய மோட்டோ. ரைட். நீங்க எந்த ஊரு? சொந்த ஊர்?
சார் நாங்க விருதாச்சலம் சார்.
விருதாச்சலம், விழுப்புரம் பக்கம். எஸ் ஐ நோ. திருச்சி, adjacent to திருச்சி.
Yeah, yes.
I was at Virudhunagar Nadar College.
Oh, okay sir, okay sir.
BA படிச்சது அங்கதான்.
Okay sir, South Virudhunagarங்களா? Okay sir,
ஆமா.
Okay sir.
Right, thank you.
Thank you sir, thank you sir.
Welcome.
Sir, one more question from my end.
Please sir, please.
Just little different, probably this. So in, I think, contract to subject, I have read somewhere that ostensible owner cannot do the gift deed, but they can sell the properties.
Yes.
I just want to understand the intention of
Ostensible owner first you see that whether he is having a right of ownership or not, because he is having, nobody is there title to the property, but he become the owner having possession of more than 12 years, adverse possession. He become an ostensible owner, so he can alienate the property, no?
Yeah, but I think he cannot make it a gift deed. That's what
I
read.
No. Until and unless he get the decree of declaration to prove that he is absolute owner by virtue of enjoying the property more than 12 years between the parties, or more than 30 years between the government.
Okay, sir. Got it.
Yes.
Hello.
Yes.
Sir, I have one doubt.
Please. No,
actually, the property related. Shall I speak in English or Tamil, sir?
No problem. Any language.
Okay, sir. Okay.
Actually,
married woman. Our husband and wife வந்து 7 years வந்து வாழல, ரெண்டு பேருமே வாழல. டிவோர்ஸும் பண்ணல. அவங்களுக்கு இருக்கிறது ஒரு ப்ராப்பர்ட்டி, அதாவது ஐ மீன் ஜென்ஸ்க்கு, அதாவது கணவருக்கு இருக்கிறது வந்து ப்ராப்பர்ட்டி வந்து 3 சென்ட் ஒரு இடம் மட்டும் தான் வச்சிருக்காரு. எல்லாத்தையும் சேல் பண்ணிட்டாரு. இப்ப சேல் பண்ணிட்டாரு. கடைசியா இருக்கிறது ஒரு 3 சென்ட் நிலம் மட்டும் தான் வச்சிருக்காரு. 3 சென்ட் இடம் மட்டும் வச்சிருக்காரு. அந்த ஹஸ்பண்ட் அண்ட் ஒய்ஃப் ஒரு பையன் இருக்கான். பட் அந்த உமன் வந்து டிவோர்ஸ் எல்லாம் கொடுக்கல. அவங்க டிவோர்ஸும் கொடுக்கல.
இது ancestral property தானே இது? Ancestral property, child is also having right over the property. He can claim.
விக்லான் இருக்காங்க, 3 சென்ட் விக்லான் இருக்காங்க. அவங்க என்ன மேரேஜ் டிசோல்யூஷன் ஆகல.
Because this property has been kept for their family, to develop their family, so therefore she is not cooperating. You have to file a suit before the family court and get the dissolution for desertion, willful desertion, more than 3 years, you are entitled for divorce. You have to file, and she cannot claim ownership of the property because it is ancestral property. Though it is not gift away to her, but it has been kept. It is not a gift away or transferred in her name. So this is the. Sir, she can object because of she is a member of Hindu family. That's all. Okay. Divorce ஆனாத நீங்க சரி நீங்க செய்யல அவ்வளவுதான் டைவர்ஸ் எடுக்கணும் otherwise it is not claim பண்ணலாம் ஆமா
ஃாதர் இல்லாம இருக்காரு கணவரும் இருக்காங்க ரெண்டு பேரும்
ஆமா
थैंक यू சார்
வெல்கம்
டிவோர்ஸ் நோட்டீஸ் விட்டுட்டு வேணா கண்டினியூ பண்ணலாம் மெயின்டெனன்ஸ் கேட்கலாம்
ரைட்
ஓகே थैंक यू சார்
You are getting advantage for this session for your career in future. I think it is advantage for you.
Grammarly can help you write quickly and confidently.
So it's definitely useful to understand the once we read in a theoretical thing.
Yeah.
But practically you're giving some things to us, so it's really helping to us to understand, at least for at this moment, to understand the what those sections, what is there behind and all, is that really helping to us?
Because what happened tomorrow, the gift means you shall explain, and relating to those judgment I have given, you can use for that and write the examination point of view. It is better for you, I think so.
So definitely, sir.
Thank you. Shall I close, sir, now?
Yes, sir, in case there is no question.
Yeah. If any question, you please ask. No problem.
Thank you, sir. Thank you.
Thank you, sir.
Thank you, sir.
Thank you, everybody.